Have you ever thought about how one tiny mistake, a single typo, could unravel years of hard work? Well, that's not just a bad dream. It's the absolutely wild, true story of Synertec, an Australian company that had to fight to save their groundbreaking invention from disappearing into a bureaucratic black hole. And in this explainer, we're going to break down exactly how it all went down.
I mean, it's a huge question, right? How much power should one little human error have when a massive innovation is hanging in the balance? To get to the bottom of that, we first have to understand how Synertec's incredible invention just vanished. Okay, so let's set the stage. This whole story kicks off not with some big explosion, but with a quiet, horrifying discovery for this Australian company, Synertec. They thought their patent application over in India was chugging along smoothly. Turns out they were about to find out it had basically ceased to exist. So here you have it, the two sides of the coin. On one hand, you've got this really cool, innovative tech for measuring liquefied natural gas, which, trust me, is a huge deal in the energy world. And on the other hand, you have its terrifying legal status in India, deemed to be withdrawn. Now, this isn't just a delay or a slap on the wrist, this is a legal knockout. It meant their application was, for all intents and purposes, dead in the water.
So what in the world does that legal speak actually mean? Well, deemed to be withdrawn is kind of like an automatic ejection button in patent law. If you miss a super important deadline, the system just assumes you've given up on your invention. It's not a fine, it's a total forfeiture. You lose all your rights to that invention in that country. Gone. Poof. The stakes just don't get any higher than that.
So, the big question is, how on earth did this happen? How does a major patent application for a major invention just fall off a cliff like that? Well, as we're about to see, it all came down to a simple, painfully human mistake, a docketing error that basically created a phantom year out of thin air.
Okay, let's follow the breadcrumbs on this timeline. It all starts back in November 2019 with the priority date. You can think of this as the official birthday of the invention's paperwork. Now jump forward to October 2022. Synertec's agent in India sends this really important email. But, and this is the killer part, they get the deadline wrong. They say it's in 2024. The real deadline, the one calculated from that 2019 birthday, was actually November 2023. So by the time Synertec followed up, the clock had already run out, a whole year before. Ouch.
And this right here shows you exactly where the math went completely sideways. That 48-month clock was supposed to start ticking from the original Australian filing in 2019. But the agent mistakenly started the clock from the international filing date a year later in 2020. It was a simple mix-up of which start date to use. But that tiny difference created a fatal one-year gap.
With their patent application essentially in the trash, Synertec had one last, desperate hope: the High Court of Delhi. And this, my friends, set the stage for a classic legal showdown: the inventor's clear intentions versus the cold, hard letter of the law.
So on one side, you have Synertec's argument, which was all about fairness. They were basically saying, look, we obviously never meant to abandon this. We've got a patent in the US. This was 100% our agent's mistake, and we shouldn't have to lose our invention because of it. But the government's response was super procedural. They said, hey, we didn't do anything wrong. The law is automatic. A deadline was missed. The system did exactly what it's supposed to do. No error on our end.
And this brings us to the absolute core of the legal problem. In a case like this, what should matter more? The rigid, automatic rule that triggers when a deadline is missed, or the clear, obvious intention of the inventor who made an honest and accidental mistake? This is where the court's thinking gets really, really interesting. This quote from the judge, Justice Aroa, just perfectly captures the court's whole vibe. It's so powerful. She's essentially saying that such a devastating consequence shouldn't fall on an applicant for something that wasn't even their fault. You can see right away that the court is leaning towards fairness over just blindly following procedure. So the court really broke its decision down into these four key pillars. First, it was just crystal clear from everything Synertec did that they had absolutely zero intention of abandoning their patent. Second, the company was diligent. They were following up, they were getting patents in other major countries. Third, the mistake was squarely and solely on the agent. And finally, and this is a big one, the consequence of losing the entire invention was just a punishment that didn't fit the crime. It was, as the court saw it, way too harsh for a simple typo. Now this gets to the legal bedrock of the whole decision. The court leaned on a really important principle, one that we've seen in other cases. The idea is simple. A mistake made by a patent agent should be treated just like a mistake made by a lawyer. And the law generally says that clients shouldn't have to suffer the ultimate penalty because their legal expert messed up. So this wasn't just the judge making a gut call. It was them applying a solid legal idea that allowed them to look past the automatic rule and see the human reality of what happened. So, after weighing the inventor's hard work against their agent's simple mistake, the court reached its final decision. Let's take a look at the verdict and the pretty powerful lesson it sends.
And the verdict was as clear as it gets. The High Court sided with Synertec. The patent application was officially restored, literally pulled back from the edge of extinction. It was a huge victory for common sense and fairness.
The court didn't just say you win and walk away. It gave very clear instructions. First, it ordered that scary deemed withdrawn status to be completely wiped from the record. Second, it told the Patent Office to revive the application, basically bringing it back to life. And finally, it gave Synertec a fresh 2-week window to get the right paperwork filed. The error was, for all intents and purposes, erased.
So, what's the big takeaway from this whole incredible story? It's that while rules and deadlines are absolutely the backbone of our legal system, sometimes true justice means looking past the rigid code and focusing on what someone intended to do. The Synertec case doesn't just save one company's invention, it sets a really important precedent. It tells us that the law can be flexible enough to know the difference between someone giving up and someone just making a simple human mistake. And that's crucial because it ensures a potentially world-changing invention isn't sacrificed because of a single typo.